South Africa's Trespass Act of 1959 is a relic of apartheid legislation. That's according to the Justice Department. And so it will be repealed and replaced, and that's been a proposal. The unlawful entry on premises bill aims to do exactly what it says, prohibit unlawful entry onto premises. It's open for public comment until the 16th of September. To talk about it some more, with me in the studio, we've got Justice Ministry spokesperson Crispin Phiri. Crispin, thank you so much for making the time to come in at this late hour on a Wednesday night. Really interesting work on top of all of the other daily duties that you have. So probably more sort of paperwork, as it were, but important paperwork. You've said to me that, just now, before we started this interview, that this specific law is not specifically unconstitutional, but it is problematic, I'm assuming. Talk to us about some of the legalese inside the Trespass Act of 1959 and why the department felt it necessary to repeal it and replace it at this time.
Yes, so indeed, duty calls, so I'm here on a Wednesday night. But indeed, so this act, when it was originally passed, was an act designed to ensure that black people are not able to gather on a vacant piece of land. And so then it was a lot more easier to prosecute people under so-called trespassing laws. But once the constitutional dispensation came in, some parts of it which were problematic were repealed, and what remained was just the thrust of ensuring that people do not trespass on premises that they're not supposed to trespass on. But what we found is that it's not in line necessarily with our land laws as well. So your Prevention of Illegal Occupation Act, your PIAs, your Extension of Security of Tenure Act, your ESTAs, it's not in sync with those type of laws. So you need now a new law to ensure that when we speak of trespassing, when we speak of an illegal occupant, it also meets the standard of other legislations as well that would deal with land occupation in general. But it also places an important duty, for instance, on landowners now to ensure that they erect the proper fence on their land and clearly mark it that, this land starts here and ends here, but also entry is prohibited so that it's clear that this land is people are trespassing, and so that we can deal with that particular crime. Also dealing with the offence of ensuring, or also dealing with the issue of ensuring that you are able to legally define what a legal occupant is versus an illegal occupant.
And obviously there's a lot of legalese involved, and the wording is very, very important, because this would deal with what the act of trespassing actually is in itself, but also what rights the owner of that property or that land or whatever you're dealing with, what right do they have to defend that space, whose right it is to let law enforcement know that there's a trespasser. How does it address that part of unlawful entry?
Yes, so firstly, like I said, it sets a burden on landowners, for instance, to erect a proper fence and mark the properties. I know this is private property, you may not enter here. But also then it creates a new threshold to ensure that when someone is found to be trespassing, you can verbally inform them that you are trespassing on this land, and that's good enough notice to a trespasser. And if they do not act on that, then you can call upon the police, who would ensure that they effect the law. And if one doesn't pay the required fine, or even doesn't adhere to what is expected, they may be incarcerated to more than 2 years, or not more than 2 years in a correctional facility, which is a bit steep for finding yourself on property that you should not be on in the first place.
And now, according to your statement, you said that the original Trespass Act was designed to combat trespassing, publications and conduct engendering hostility between certain population groups. And it's in 1959, and we all know what 1959 South Africa looked like going forward. Now, the minister said that there are parts of the statute book that are problematic. Has it taken this long to start getting to those acts that are still sort of hidden in the deep and dark crevices of the statute book that really shouldn't be there anymore? And that's why I asked, why now? Why are we getting to this now? Some might say, why are we only getting to this now?
So a lot of work has been done to deal with apartheid-era laws. A lot of them have been repealed or slightly revamped to ensure that the problematic parts, which were overtly apartheid fostering or colonialist in nature, have been removed. But for instance, the State Capture Commission was initiated by the Commissions Act, and it still, for instance, has a penalty of £10 or something like that if you don't go to the commission or you don't adhere with the requirements of the commission. Small little nooks like that still need to be addressed. For instance, the Extradition Act that we use now currently doesn't recognize the fact that we have multilateral institutions in the world. So if a UN body would want to extradite someone for a crime, in terms of our extradition law, because it's a 1962 act where people didn't think of multilateral institutions would have that type of power, we can't do so. So those are the type of formulations that we now need to start introducing in some of these acts. Some of them can still be revamped. We can completely just remove a certain part of the law and replace it with another, but some of them completely need to be repealed, and we need to just completely rethink the type of problem that we're trying to solve. And so it will take work, it will take time, and because the law is also not static, so some of these things present themselves over time. Had we not had, for instance, a big commission of inquiry of this nature, we would have never known that an individual can get fined £10, you know. So some of these things reveal themselves over time because not all of these acts are being used all the time at a particular goal. But now we are seeing, for instance, a huge increase in trespassing. Buildings are getting hijacked, and we're finding that maybe this law is actually not suitable enough to deal with the type of problems that society faces today. But then you also look deeper and you realize that in a constitutional democracy, trespassing has its own nuances, and we need to ensure that when we enforce trespassing laws, we do so in a way that doesn't infringe upon the dignity of an individual, both on the property owner side, but as also someone who may be deemed an illegal occupant of a space.
Let's talk about those hijacked buildings, though, because that is, especially in a city like Johannesburg, you know, you don't open a newspaper or website, as it were, without seeing stories around hijacked buildings, either in the city or in the suburbs. So, you know, I think I read a story in passing a while ago saying that that is on the increase because of the current economic situation, and the list goes on. Once this new act is passed, how will it impact on a property owner's right to make sure that trespassers are removed from a property that has, quote unquote, been hijacked?
Well, then I think the whole point is to ensure that it makes it easier for us to deal with the act of trespassing. Whereas currently now, one may be deemed a lawful occupant in various ways, and it's quite debatable. But now this piece of legislation will delineate the issues of occupation and the issue of trespassing quite clearly. So we are able to ensure that where we know that this is trespassing, we remove people. So the crime of trespassing becomes a lot more clearer. Whereas under the status quo now, it's a bit murky as to where one becomes a trespasser or not. Even government, by the way, is faced with the same situation. For instance, we know that in Marikana, where the government has built houses, those houses have been unlawfully occupied by people there and so have been trespassed. So how do we ensure that we deal with that? So it's a problem across the board.
Let us in on the inner workings of the department. Whose job is it to make their way through the statute book to ensure that all of those relics from days gone by are either reworked or repealed or replaced? Do you have a team of bright young things that you're tying up in a basement, making sure that they read everything? Well, how does it work?
We are ably assisted by the South African Law Reform Commission. And they've been assigned this project of reforming and repealing apartheid-era laws. So they are a team of experienced and also bleeding in young people who would like to believe, who are there to be able to look at some of these laws and revamp them. But this one is specifically done by the department's legislative development unit. And there too, I can affirm that there are bright young people who are hard at work, who are doing incredible work around reforming our legislation. But what this presents for us, Marcel, is quite a very important opportunity. I think we're quite glad for this platform because we're able to say to South Africans, here's an opportunity for us to think about a problem that we are all faced with in various manifestations. Government alone can't think of all of the manifestations around how this problem manifests itself in society. So here's an opportunity to comment on this bill. Approach the Department of Justice with your comments before the 16th of September. And give us your views about what you think of this bill and how we can improve trespassing laws. And that's how we improve the laws in our country, by ensuring that everyone gives their voice, but also the law becomes a lot more richer if it takes into cognizance the lived experience of many people.
Okay, we're going to leave it there. You heard it here. Until the 16th of September, you have an opportunity to weigh in on the unlawful entry on premises bill set to reform South African trespassing laws. Thank you so much for your time. Crispin Perry, Justice Ministry spokesperson. Thanks for your time this evening.